Hi, this is Richard Chamberlain, and welcome back to the Protecting Your Family's Future podcast. This is episode number 131. Today, we're going to be talking about three important provisions that might not be in your revocable trust. We review a lot of trusts that have been prepared by other attorneys, and what we find is a lot of them don't have some very important provisions that should be in every revocable trust. Now, the first one is disability or incapacity provisions. Your trust needs to work for you if you become incapacitated. There needs to be somebody who is named as the successor trustee, and I'm sure there is. And the job of the successor trustee is to manage the assets in the trust and use them to take care of you if you become incapacitated. However, if your trust does not have provisions in the trust that define what your incapacity is or provide a mechanism for determining how we know if you are incapacitated, then someone needs to go to court and have you adjudicated to be incompetent by a judge in order for the incapacity provisions to kick in. And one of the reasons why you have a trust in most cases is so that nobody has to go to probate court to have someone adjudicated to be incapacitated or to probate their estate when they die. So, having those incapacity provisions in your trust is important because it lets the trustee know when they need to take over. The other provisions that need to be in the trust with regard to your disability is how should the assets be used. So specific instructions perhaps on how the assets can be used to provide for you and or your spouse and or anyone who's dependent on you. All those types of provisions should be in the trust to cover your possible incapacity. Now, the next provision that we often see missing from trusts is what we call a no contest clause. That is a provision that says that if a person tries to contest the validity of the trust agreement, they try to have it thrown out, essentially, then that person is deemed to have predeceased the trust maker, meaning they receive nothing anyway. So that's an important provision to discourage people from trying to contest the trust, to have it thrown out. It's your plan. You're entitled to make decisions about who gets what and how. And if people want to contest that, then they do that at their own peril with that no contest clause in there. So that should be included as well. The last provision that we want to make sure is included in every revocable trust is a spendthrift clause. And that is a provision that says while assets are held in trust for a beneficiary, their creditors cannot compel distributions from the trust. The beneficiary cannot use the assets in the trust to pay debts or to get a loan. It essentially protects the assets in the trust share from the beneficiary's creditors and in some instances from the beneficiary themselves. So that's an important provision to have in there. You want to make sure that your trust includes that. So to sum up, you want to make sure that your trust has disability provisions, a spendthrift provision, and a no contest clause. So if you have questions about your own plan and you want to make sure that your plan will work the way you want it to, if you live in Ohio or in Michigan, you can reach out to us and we can help you with that. Our contact information is in the show notes. And I hope that's helpful for you today, and we'll see you again next week. Thanks.